I was drinking my morning coffee when I saw her marching across my lawn like a general inspecting enemy territory, and I knew my peaceful Saturday in Boulder, Colorado, was about to go straight to hell. Her name was Patricia Henderson, the president of the Meadowbrook Heights Homeowners Association, and she had that particular look on her face that middle-aged HOA enforcers get when they think they have caught you violating some obscure rule buried in paragraph 17 of Section 9. She wore a khaki vest covered in pockets, the kind you would see on a safari guide, except instead of binoculars, she carried a leather-bound binder that I knew contained every single HOA regulation ever written since our development was built in 1998. I set down my coffee and walked to the front door, opening it just as she raised her fist to knock. "Lucas Ramsey," she said, not asking, just stating my name like it was an accusation in itself. "Morning, Patricia. What can I do for you?" She did not waste time with pleasantries. "Your detached garage is in violation of community regulations. We are going to need you to remove it." I blinked, certain I had misheard. "I'm sorry, what?" "Your garage," she repeated, gesturing toward the two-car detached structure that sat about 30 feet behind my house. "It is built on common land. According to HOA property records, that section of your lot is actually community property, designated for open green space. The structure needs to come down within 30 days, or we will take legal action." My jaw must have hit the floor. I had bought this house 3 years ago in 2023, and that garage had been sitting there for over 2 decades. The previous owners, an elderly couple named the Harrisons, had built it back in 2001, according to the county records. It matched my house perfectly, same gray siding, same architectural shingles on the roof. I used it to store my woodworking equipment, my truck, and basically half of my life. "That is impossible," I said, trying to keep my voice level. "The garage has been there for 25 years. It was here when I bought the place. I have a deed that shows the entire property line." Patricia opened her binder with the practiced efficiency of someone who had done this 1,000 times. She pulled out a photocopied map that looked like it had been drawn by someone using a ruler and a lot of confidence. "This is the official HOA plat map from 1998. As you can see, the common area extends 15 feet further east than your property line. Your garage sits approximately 8 feet into that common area." I took the paper from her hands and studied it. The map was crude at best, with hand-drawn lines and annotations that were barely legible. It looked nothing like the professional survey that had been done when I purchased the house. "This map is almost 30 years old and looks like it was drawn on a napkin," I said. "I have an actual survey from 2023 that shows exactly where my property ends. The garage is well within my boundaries." "HOA records supersede individual surveys," Patricia said with the absolute certainty of someone who had never been challenged. "We have consulted with our attorney, and the law is clear. If the structure is on common land, it must be removed. You will receive official notice within 3 business days." She turned on her heel and marched back across my lawn, leaving me standing in my doorway holding a ridiculous map and wondering what alternate reality I had just stumbled into. I went back inside and pulled out the massive folder of paperwork from when I had bought the house. The survey was right there, a professional document prepared by Alpine Land Surveying, a reputable firm out of Boulder. It showed my property boundaries clearly marked with actual GPS coordinates, physical markers, and references to the original 1998 subdivision plat. My garage was definitely, absolutely, 100% on my land. I called my real estate attorney, Margaret Chen, first thing Monday morning. "They are saying what?" Margaret asked after I explained the situation. That my garage is on HOA common land and needs to be demolished. I heard her typing on her keyboard. Send me everything you have. The HOA letter when you get it, your survey, your deed, and whatever crazy map they gave you. This sounds like complete nonsense, but I want to see what we are dealing with. The official letter arrived by certified mail on Wednesday. It was even worse than Patricia's verbal warning. According to the HOA, not only was my garage on common land, but I also owed them 3 years of back fines at $500 per month for the unauthorized structure. They were demanding $18,000 plus the cost of demolition, which they estimated at another $12,000. $30,000 for a garage that had been legally permitted and standing for a quarter century. I scanned everything and sent it to Margaret, then sat at my kitchen table feeling like I had been punched in the gut. I had bought this house specifically because of the garage. I was a furniture maker and that space was my workshop. Without it, I would have to rent commercial space I could not afford or give up my business entirely. My phone rang an hour later. It was Margaret and she sounded angry. "This is the most ridiculous thing I have seen in 15 years of practice," she said. "Their map is not an official survey. It is literally just a sketch map that someone made for general reference. It has no legal weight whatsoever. Your survey is based on the actual recorded plat, which was filed with Boulder County and has physical monuments that were verified. There is no question that your garage is on your property. So what do I do?" "We are going to send them a letter explaining that they are completely wrong and need to retract this immediately. I am also going to point out that if they continue with this harassment, you will have grounds for a lawsuit against the HOA for abuse of power and intentional infliction of emotional distress." "Will that work?" Margaret paused. "With reasonable people, yes. But HOAs are not always staffed by reasonable people. Be prepared for this to get ugly." She was right. The HOA's response came back within a week, and it was basically a middle finger in legal language. Their attorney, a guy named Richard Dunmore from a firm in Denver, claimed that the original subdivision plat was ambiguous, that the HOA had been managing the disputed area as common land for decades, and that I had no right to maintain a structure on it, regardless of what my survey said. They were not backing down, and they were moving forward with fines and legal action. "They are doubling down," Margaret told me, which means either they genuinely believe they are right or there is something else going on here. Like what? I do not know yet. But HOAs do not usually pick fights like this unless someone has a reason. Start asking around your neighborhood. Find out if there is any history here that we do not know about. I took her advice and started talking to my neighbors. The house to my left was owned by Tom and Jennifer Kozlowski, a couple in their 60s who had been there since the beginning. "The HOA is coming after you," Tom asked when I brought it up over his fence on Saturday morning. "That does not surprise me one bit." "Why not?" He leaned in conspiratorially. "Patricia Henderson has been trying to consolidate power in this neighborhood for years. She and her cronies on the board, they have got some kind of plan to develop the common areas. There have been rumors about bringing in a management company, building a fancy clubhouse, maybe even putting in tennis courts. All stuff that would increase property values for the houses closest to the amenities. Where is my garage in all this? Your lot backs up to the biggest chunk of undeveloped common land we have. If she can claim that area is HOA property, that is probably another half-acre they can develop. But here is the thing, Lucas. That land has always been understood to be part of the private lots. The Harrisons, the people you bought from, they fought the HOA 15 years ago about this exact same issue." I felt my stomach drop. What happened? The HOA tried to say their shed was on common land. The Harrisons got a survey done, proved the HOA was wrong, and the HOA backed down. But now the Harrisons are gone, and Patricia probably thinks you are an easier target. This was making more sense now, and it was making me angrier. This was not about property lines or regulations. This was about a power play and a land grab. I called Margaret back and told her what I had learned. "That changes things," she said. "If the HOA tried this before and lost, and now they are trying it again with a new owner, that shows a pattern of harassment. We need to find out what happened with the Harrisons." "Do you have contact information for them?" I did not, but the Kozlowskis did. Tom gave me an email address, and I sent the Harrisons a message that evening explaining what was happening. Gerald Harrison called me the next day from his retirement home in Arizona. "I cannot believe they are pulling this garbage again," he said, his elderly voice crackling with indignation. "We fought them for 2 years. It cost us thousands in legal fees, but we won. We had the original survey from when the subdivision was first platted. It showed clear as day that our property line extended to the tree line, which is exactly where you have your garage now. Do you still have any of the paperwork from that case? I've got boxes of it. I will overnight you copies of everything. The survey, the court filings, all of it. You tell that Henderson woman that she is going to lose again, just like she lost last time." True to his word, a large box arrived 3 days later. Inside were dozens of documents, including a survey from 2009 that matched my 2023 survey almost perfectly. There were also letters from the HOA making the exact same claims they were making now, and court documents showing that a Boulder County judge had ruled in favor of the Harrisons, declaring that the garage was unequivocally on private property and ordering the HOA to cease harassment. Margaret nearly cheered when I brought the documents to her office. "This is exactly what we need," she said, spreading the papers across her conference table. "They are trying the exact same thing they tried before. A judge already ruled against them. We can use this to show bad faith and possibly even get sanctions against them. Can we make this go away without going to court? We can certainly try. Let me draft a very strongly worded letter with copies of the Harrison case attached. If they have any sense at all, they will back down immediately." But Patricia Henderson did not have sense. She had stubbornness and what seemed like a personal vendetta. The HOA's response was to double the fines and schedule a lien against my property. "They are claiming the Harrison case does not apply because it was a different structure," Margaret explained when she called me after receiving their latest letter. "They are saying your garage was built after the Harrison dispute, so it is a new violation. That is insane. My garage and their shed were the same building. The Harrisons just renovated it and made it bigger before they sold the house. I know, but they are going to make us prove it, which means we are going to court. The next 3 months were a nightmare." The HOA continued to pile on fines, threatening to foreclose on my house if I did not pay. They sent inspectors to photograph my garage. They cited me for other petty violations like having my trash cans visible from the street and letting my grass get half an inch too long. Patricia seemed to be everywhere, driving past my house at odd hours, taking pictures, documenting everything. I tried to ignore it and focus on my work, but it was impossible. Every time I went into my garage to work on a furniture piece, I felt the weight of potentially losing it all. My sleep suffered. My business suffered. I started losing clients because I could not focus on deadlines. Margaret filed our response in Boulder County District Court in June 2026, asking for a declaratory judgment that would officially confirm my property boundaries and stop the HOA's harassment. We also filed a counterclaim for abuse of process and requested attorney's fees. The HOA fought us every step of the way. Their attorney, Dunmore, filed motion after motion trying to delay the case. He demanded depositions. He requested document production. He even tried to get the Harrison case records sealed so we could not use them as evidence. He is running up the bill, Margaret told me after a particularly frustrating hearing in August. This is a standard HOA litigation tactic. They have insurance that covers their legal fees, so they do not care how much it costs. They are betting that you will run out of money before they do and be forced to settle. I am not settling, I said. They are wrong and they know they are wrong. This is about principle now. Good. Because I think we are going to win, but I need you to be prepared for this to get expensive. She was not kidding. By September, I had spent over $20,000 in legal fees. I had to take out a loan against my house to cover it. The stress was killing me, and Patricia Henderson seemed to be enjoying every minute of it. The trial was set for October 15, 2026. Margaret spent weeks preparing, gathering evidence, interviewing witnesses. She tracked down the original surveyor who had platted the subdivision in 1998, a retired engineer named Douglas Park, who still lived in Boulder. He agreed to testify that the original plat clearly showed the property lines extending to where my garage sat, and that the HOA's sketch map was never intended to supersede the official recorded documents. We also brought in the surveyor who had done my 2023 survey, a woman named Rachel Ortiz who had 30 years of experience. She was prepared to explain in excruciating detail exactly how she had located the property boundaries using GPS equipment, physical monuments, and county records. The night before trial, I barely slept. I kept running through worst-case scenarios in my head. What if the judge believed the HOA? What if I lost my garage, my workshop, my livelihood? What if I ended up owing them $30,000 plus all their legal fees? Margaret met me outside the courthouse at 8 in the morning. She was wearing a sharp navy suit and carrying 2 briefcases full of documents. "Ready?" she asked. "No, but let's do this anyway." The courtroom was smaller than I expected, with wood paneling and fluorescent lights that hummed faintly. Judge Robert Castellano presided, a stern-looking man in his early 60s with gray hair and reading glasses perched on his nose. Patricia Henderson sat at the plaintiff's table with Richard Dunmore and another HOA board member, a thin man named Kevin Walsh, who always looked like he had just tasted something sour. They had a smug confidence that made my blood boil. The trial started with opening statements. Dunmore went first, spinning a tale about how the HOA had a responsibility to protect community property and ensure that homeowners did not encroach on shared spaces. He made it sound like I was some kind of land thief who had deliberately built my garage on property that did not belong to me. Margaret's opening was sharp and direct. She laid out the facts: the original 1998 plat, the physical monuments marking the property line, my professional survey, the Harrison case from 2009, proving the exact same thing, and the HOA's pattern of harassment and bad faith. "This is not a complicated case, Your Honor," she said. "The evidence will show clearly and convincingly that Mr. Ramsey's garage is on his property, that it has always been on private property, and that the HOA knows this, but is pursuing this action anyway for reasons that have nothing to do with legitimate enforcement of community rules." The first witness was Patricia Henderson herself. Margaret Cross examined her with surgical precision. "Miss Henderson, are you aware that the HOA made similar claims about this same property in 2009? Patricia shifted in her seat. "I am aware there was a previous dispute, yes." And are you aware that a judge ruled against the HOA and found that the property was privately owned? That was about a different structure. Was it? Do you have any evidence that the current garage is different from the structure that existed in 2009? Patricia fumbled with her papers. The building was renovated. Renovated, not relocated. The foundation is the same, is it not? I do not know the details of the construction. Margaret pulled out photographs from the county permit records. These are photos from the 2019 renovation permit filed by the Harrisons. As you can see, they show the same foundation, the same location. The only changes were to the exterior siding and the roof. The structure is in the exact same place. You knew this, did you not? Patricia's face reddened. The HOA has a responsibility to protect common areas. That was not my question. Did you know that this garage is in the same location as the structure that was ruled to be on private property in 2009? I knew there was a previous case, yes. And you proceeded with this action anyway, knowing that a judge had already ruled against the HOA on this exact issue. Dunmore objected, but Judge Castellano overruled him. Patricia had to answer. We believed we had a valid claim, she said weakly. Based on what new evidence? Silence. Margaret let that hang in the air for a moment before continuing. Miss Henderson, is it true that the HOA board has been exploring plans to develop the common areas adjacent to Mr. Ramsey's property? We have discussed various community improvement projects, including a clubhouse and tennis courts. Among other ideas, yes. And those improvements would require significant land area, would they not, I suppose? Land area that you would gain if you could claim that Mr. Ramsey's garage is on HOA property, correct? Patricia's lawyer jumped up to object, but the damage was done. The implication was clear. This was about grabbing land for development, not about enforcing legitimate rules. Next came Douglas Park, the original surveyor. He was a grandfatherly figure with a calm demeanor and an encyclopedic knowledge of the subdivision. I personally surveyed this entire development in 1998, he testified. I placed the physical monuments that mark the property corners. I prepared the official plat that was recorded with Boulder County. Mr. Ramsey's property line, Lot 47, extends 95 feet from the rear of his house to the tree line. The garage in question sits approximately 75 feet from the house, well within the property boundary. Margaret introduced the original plat, blown up to poster size, showing the precise measurements. Is there any ambiguity in this plat regarding the location of the property line? Margaret asked. None whatsoever. The measurements are clear, the monuments are marked, and the legal description is precise. Have you seen the map that the HOA is using to claim the garage is on common land? Douglas adjusted his glasses and looked at the photocopy Patricia had given me. He actually chuckled. This is not a survey. This is a sketch map, probably made by a board member for general reference. It has no scale, no measurements, no surveyor's seal. It would have no legal validity. Could someone make a mistake using this map? Absolutely. Without proper measurements and reference points, this map is essentially useless for determining actual property boundaries. Dunmore tried to rattle Douglas on cross-examination, suggesting that perhaps the monuments had been moved or that the measurements could be off due to GPS errors. Douglas calmly explained that the monuments were checked and verified multiple times, including during my 2023 survey, and that GPS technology in modern surveying was accurate to within inches. Rachel Ortiz, my surveyor, testified next. She brought detailed maps, photographs, and technical data showing exactly how she had located my property boundaries. I used a combination of GPS technology, physical monuments, and county records. she explained. "I located the original iron rods that Mr. Park placed in 1998. They were still there, exactly where the plat said they would be. I then measured and verified all boundary lines. The garage is 13 feet inside the property line at its closest point to the boundary. There is no question that it is on private property." She also brought up something I had not even thought about. If the garage were on common land as the HOA claims, it would actually be in violation of county setback requirements, because common land has different setback rules than private property. The county would never have issued a building permit for that location if it were on HOA land. The fact that the county approved the permit in 2001 is further evidence that everyone understood this was private property. That was a brilliant point, and I could see Judge Castellano taking notes. The HOA's case fell apart when Dunmore tried to present their evidence. He called a surveyor they had hired, a guy named Martin Jeffries who had a thin resume and a nervous demeanor. Under Margaret's cross-examination, Jeffries admitted that he had never actually visited the property. He had based his opinion solely on the HOA's sketch map and had not verified any physical monuments or county records. "So your testimony is based entirely on a hand-drawn map with no scale or measurements, and you never bothered to check whether that map was accurate?" Margaret asked. "I was told by the HOA that the map was reliable," Jeffrey stammered. "But you did not verify it yourself." "No. And you are aware that 2 other professional surveyors with decades of experience have testified that the garage is on private property." "I have heard their testimony, yes." "Do you have any evidence that contradicts their findings?" Jeffries looked at Dunmore, who could not help him. "No, I do not." The final blow came when Margaret introduced evidence of the HOA's fines and threats. She presented a timeline showing how the HOA had escalated from a simple claim to thousands of dollars in fines to threats of foreclosure, all within a few months, and all without any real evidence to support their position. "This is not good faith enforcement of community rules," Margaret argued in her closing statement. "This is harassment, intimidation, and an attempted land grab. Mr. Ramsey has provided clear, convincing, and overwhelming evidence that his garage is on his property. The HOA has provided nothing but a sketch map and bad faith. We ask the court to rule in Mr. Ramsey's favor, to declare the property boundaries definitively, and to award attorneys' fees and sanctions against the HOA for their abuse of the legal process." Dunmore's closing was weak and defensive. He tried to argue that the HOA was just doing its duty, but even he seemed to know the case was lost. Judge Castellano did not take long to deliberate. He came back after a 30-minute recess and delivered his ruling from the bench. "I have reviewed all the evidence presented, and the conclusion is inescapable," he said. "Mr. Ramsey's garage is unquestionably on his private property. The surveys, the physical monuments, the county records, and the prior litigation all point to the same conclusion. The HOA's map has no legal validity and appears to have been used to justify an action that the HOA knew, or should have known, was without merit." He looked directly at Patricia Henderson. "I am particularly troubled by the fact that this HOA pursued this action despite a prior court ruling on the same property. That suggests either gross incompetence or willful misconduct. Either way, it is unacceptable. He ruled in my favor on all counts, declaring that my property line extended to the tree line, and that my garage was lawfully situated on my land. He also awarded me attorney's fees, which came to nearly $30,000, and imposed an additional $5,000 sanction against the HOA for bad faith litigation. I felt like I could breathe for the first time in months. Outside the courthouse, Margaret shook my hand with a genuine smile. "You did it. You stood up to them and won." "We did it," I corrected. "I could not have done this without you." Patricia Henderson stormed past us without a word, her face red with anger and humiliation. Kevin Walsh followed her, looking even more sour than usual. The aftermath was surprisingly satisfying. The HOA had to pay my legal fees, which nearly drained their reserve fund. At the next HOA meeting, which I attended with about 30 other fed-up homeowners, there was a vote of no confidence. Patricia Henderson was removed as president, and Kevin Walsh resigned from the board entirely. New board members were elected, including Tom Kozlowski, who ran on a platform of transparency and reasonable enforcement. The first act of the new board was to commission a professional survey of all common areas and property boundaries in the neighborhood, so there would never be confusion again. They also issued a formal apology to me and rescinded all the bogus fines they had issued. I got a call from Gerald Harrison a few weeks after the trial. He had heard about the outcome and was thrilled. "I knew you would win," he said. "That HOA needed to be put in their place. I am just glad you had the guts to fight them." "I did not have much choice," I said. "They were trying to take my livelihood." "Well, you did the whole neighborhood a favor. I heard Patricia Henderson is moving out of state. Good riddance." That rumor turned out to be true. Patricia listed her house in December and moved to somewhere in Texas by January 2027. I never saw her again. Life slowly returned to normal. My business picked back up as I could finally focus on my work instead of legal battles. I finished a custom dining table for a client in Denver that won me a feature in a local design magazine. I started taking on apprentices, teaching woodworking to high school students on weekends. My garage, stood solid and unmoved on my property where it had always belonged. Every time I walked into it, I felt a sense of satisfaction. Not just because I had won, but because I had stood up for what was right even when it was hard and expensive and stressful. Tom Kozlowski and I became good friends. He told me stories about the old days of the HOA, back when it was just a group of neighbors helping each other out rather than a petty fiefdom run by power-hungry board members. The new board tried to recapture some of that spirit, focusing on community events and genuine neighborhood improvement rather than rules enforcement and fines. One Saturday in March 2027, almost a year after the whole nightmare began, I was in my garage working on a rocking chair when there was a knock on the door. It was a young couple, probably in their late 20s, who introduced themselves as potential buyers for the house 2 doors down. "We heard you had some trouble with the HOA," the husband said, a bit nervously. "We wanted to know if this is still a good neighborhood to buy into." I thought about how to answer that. I could have scared them off, told them about Patricia Henderson and the legal battle and the stress. But that would not have been fair or accurate. "The HOA had some problems," I said honestly. "But the neighborhood dealt with it. We got new leadership, people who actually care about the community instead of power trips. It is a good place to live now. Just make sure you read your survey carefully and know your property lines." They laughed at that, and I gave them a tour of my garage, showing off some of the furniture I had built. They ended up buying the house, and they turned out to be great neighbors. As spring turned to summer, I found myself reflecting on the whole experience. It had been one of the most stressful periods of my life, but it had also taught me some important lessons. I learned that standing up for yourself matters, even when the odds seem stacked against you. I learned that documentation and facts are powerful weapons against bullies who rely on intimidation. And I learned that communities can heal and improve when people are willing to get involved and demand better. The legal victory had been sweet, But the real win was knowing that I had protected not just my property, but my peace of mind and my ability to do the work I loved. Every piece of furniture I built in that garage felt like a small act of defiance against those who had tried to take it from me. Margaret Chen became a good friend as well. She told me she had framed the judge's order and hung it in her office as a reminder of why she became a lawyer in the first place. To fight for people who are getting screwed by those with more power, she said. Your case was exactly that. The financial strain from the legal fees eventually eased as my business continued to grow. The publicity from the design magazine led to more high-end clients, and I was able to pay off the loan I had taken against my house within 2 years. The HOA's payment of my attorney's fees helped significantly, though I would have preferred to never need a lawyer in the first place. I heard through the neighborhood grapevine that Richard Dunmore, the HOA's attorney, had lost several other cases around the same time and was facing professional sanctions for his aggressive litigation tactics. I felt no sympathy. He had been a willing participant in the HOA's bad faith campaign, and he deserved whatever consequences came his way. In the fall of 2027, the new HOA board organized a neighborhood block party, the first one in over 5 years. It was held in the actual common area behind my property, the land that Patricia Henderson had tried to claim my garage was sitting on. The irony was not lost on anyone. Tom gave a speech thanking everyone for their involvement in turning the HOA around. He specifically mentioned my case as a catalyst for change, which made me a bit uncomfortable with the attention, but I appreciated the sentiment. We learned an important lesson, Tom said to the gathered neighbors. An HOA should serve the community, not rule it. We are here to maintain property values and quality of life, not to harass our neighbors over imaginary violations. I think we are finally back on track. There was genuine applause, and for the first time since I had moved to Meadowbrook Heights, I felt like I was part of a real community rather than just a collection of houses governed by arbitrary rules. My workshop became something of a neighborhood attraction. Kids would stop by to watch me work, fascinated by the smell of sawdust and the sound of hand tools shaping wood. I started teaching informal classes, showing people how to make simple things like cutting boards and picture frames. It became a gathering place, which was exactly what I had always hoped for. The Harrison case documents that Gerald had sent me stayed in a file in my office, a reminder of the importance of keeping good records. I scanned everything and backed it up in 3 different places, just in case. I also made sure to photograph my property boundaries and keep updated surveys on file. I never wanted to go through something like that again, but if I did, I would be prepared. In early 2028, I was contacted by a reporter from the Boulder Daily Camera who was doing a story on HOA disputes in Colorado. She had heard about my case and wanted to interview me. I was hesitant at first, but Margaret encouraged me to do it. Your story needs to be told, she said. Too many people get bullied by their HOAs and just give up because they think they cannot win. You proved that you can fight back and prevail if you have the facts on your side. The article came out in March 2028 and generated a lot of response. I got emails from people all over Colorado who were dealing with similar situations, asking for advice and recommendations for attorneys. I passed them all along to Margaret, who was happy to help or refer them to other lawyers who specialized in HOA disputes. One email particularly stood out. It was from a woman in Colorado Springs, whose HOA was trying to claim that her fence was 6 inches over the property line and demanding she tear it down and rebuild it. She was elderly and on a fixed income, and the cost would have been devastating. I connected her with Margaret, and they were able to resolve the issue with a simple survey that proved the HOA was wrong, just like in my case. She sent me a thank you note months later, telling me that my story had given her the courage to fight back. That felt better than any furniture award or design feature. Knowing that my willingness to stand up to bullies had helped someone else do the same made all the stress and expense worthwhile. The years passed, and life in Meadowbrook Heights settled into a comfortable routine. The HOA functioned the way it was supposed to, handling actual community needs like snow removal and landscaping maintenance without harassing homeowners over trivial matters. Property values stayed strong, and the neighborhood had a reputation as a good place to live. I expanded my workshop in 2029, adding better lighting and ventilation, all properly permitted and unquestionably on my property. I hired 2 full-time employees and took on larger projects, including custom cabinetry for restaurants and commercial spaces. The business that Patricia Henderson had tried to destroy was thriving. Every now and then, I would drive past the house where Patricia had lived and think about how different things might have been if she had succeeded. I would have lost my garage, probably my business, maybe even my house if I could not pay the fines and legal fees. But I had fought back, armed with facts and a good lawyer, and I had won. The garage stood as a monument to that victory. A simple 2-car structure with gray siding and architectural shingles, sitting exactly where it had always been, on my property, on land that had never been in dispute, except in the minds of people who valued power over truth. On a quiet Sunday morning in the summer of 2029, about 3 years after the trial, I was in the garage working on a custom bookshelf when I heard a vehicle pull into my driveway. I walked out to find an older couple getting out of a car with Texas plates. It took me a moment to recognize them, but then it clicked. Gerald and Martha Harrison had driven all the way from Arizona to visit Colorado and wanted to see the old place. "We could not come to Boulder without stopping by," Gerald said, shaking my hand firmly. "We heard you won your case, and we just had to see the garage still standing." I gave them a tour of the property and the workshop, and we spent an hour talking about the neighborhood, the HOA, and the whole crazy situation. "You know what the worst part was?" Martha said as we sat in lawn chairs in my backyard, looking at the garage. "It was not even about the money or the structure. It was the principle. They tried to tell us that something we knew to be true was false, and they expected us to just accept it. Like reality did not matter, only their version of it." "That is exactly how I felt," I said. "Like I was living in an alternate universe where facts did not matter." "But they do matter," Gerald said firmly, "and you proved it, just like we proved it 20 years ago. Some battles are worth fighting, even when they are hard." We talked until the afternoon, sharing stories and laughing about the absurdity of HOA politics. When they finally left to continue their road trip, I felt a sense of connection and continuity. The fight I had fought was not unique to me. It was part of a larger struggle between reasonable people and petty tyrants, between facts and convenient fictions, between community and control. As I watched their car disappear down the street, I turned back to look at my garage. It was just a building, wood and nails and shingles, but it represented something more. It was proof that standing up for what is right can work. It was proof that documentation and facts and good legal representation can overcome bullying and intimidation. It was proof that homeowners do not have to be victims of overreaching HOAs. I walked back into the workshop, back to the smell of sawdust and the feel of wood under my hands, back to the work I loved in the space I had fought for. The afternoon sun streamed through the windows, illuminating floating dust particles in golden beams. My tools hung on the walls, organized and ready. A half-finished bookshelf sat on my workbench, waiting for my attention. This was my space, on my land, protected by law and common sense and the hard work of fighting for what was right. No HOA president with a power trip, no lawyer with questionable ethics, no sketch map drawn without measurements could take it away. I picked up my chisel and went back to work, the quiet satisfaction of creation replacing the chaos of litigation. The garage that Patricia Henderson had tried to claim was on common land stood solid and unmoved, a testament to truth prevailing over fiction, to perseverance winning over intimidation, and to the simple fact that some things are worth fighting for, no matter the cost. The story could have ended differently. I could have backed down, paid the fines, demolished the garage. Many people in my situation would have done exactly that, unable or unwilling to spend the time and money fighting a legal battle against an HOA with insurance-funded lawyers. But I had chosen to stand and fight, armed with surveys and historical records, and the determination to not let bullies win. And in the end, on that clear October day in Boulder County District Court, when Judge Castellano ruled in my favor and imposed sanctions against the HOA for bad faith, all the stress and expense and sleepless nights had been worth it. Justice was not always guaranteed, but in this case, in this place, with these facts, it had prevailed. The sun continued its arc across the sky as I worked, and the garage remained exactly where it had always been, where it belonged, on my property in Meadowbrook Heights, Boulder, Colorado. A simple truth that had required a court battle to confirm, but a truth nonetheless, unshakable and permanent, documented and verified, protected by law and common sense. Some battles choose you, whether you want them or not. The only real choice is how you respond. I had chosen to fight, and I had won, and that made all the difference.